Good evening. Can I get your attention, please? Good evening. May I get your attention, please? My name is Uta Poiger, and I am the Dean of the College of Social Sciences and Humanities here at Northeastern. And it's my pleasure to welcome you this evening to what is the sixth event in our series on conflict, civility, respect, peace, Northeastern reflects. It's the second event this semester, and I will start us out by saying a few words about the spirit of our series. Last winter, in a sober and heartfelt address to our community, President Aoun outlined an ambitious agenda for our university. As he put it, and I'm quoting directly here, instead of being a microcosm of society, we need to be a model for society. It is through plurality that we live up to our highest calling, to be a community dedicated to human advancement. It is in this spirit that the College of Social Sciences and Humanities and the Office of Student Affairs, together with the Northeastern School of Law, have organized this series of campus conversations. And I have to say, it is just wonderful to see a full house here tonight. And we are delighted that Michael Dukakis not only agreed to President Aoun's request to host the series, but that he and his wife are here with us today as well. Thank you very much for being a host, Michael. As you know, our theme for tonight is gay rights after gay marriage. And gay marriage, I would say, is really one of those areas of immense social changes and legal changes that I have witnessed in my lifetime, in this country as well as in other countries around the world. And at the same time, the issue of gay rights, and actually also the question of gay safety and of gay visibility, remains very much a vexing question, sometimes in this country, very often in this country, and of course, as you know, also a vexing issue around the world. I have to say that I'm just so pleased to have such a distinguished panel of both Northeastern professors and also of Northeastern alumni with us here today for this event. And actually, it would be great if the panelists would come up already, and then I will ask a couple more people who have collaborated with us to do some introductions to our series, and we will then have introductions of all the panelists. So again, just wonderful to have you here for this conversation with our audience this evening. It's then my pleasure to call Laura Wankel, who has collaborated with us and with her offices on this series. She is the Vice President for Student Affairs, and may I ask you, Dean Paul, also to come up and say a few words of introduction.
Thank you. I also would like to add my voice of welcome to all of you for joining us. It's great to see the room so full, and we've been delighted with the turnout generally, but this is truly amazing. I'm also very appreciative and grateful to our distinguished guests and presenters this evening, but wanted to take a moment to recognize Dean Poiger and her leadership throughout our work as an organizing committee. She has truly been a remarkable leader. I know we have many members of the committee in the group this evening, and they too have been stellar in their commitment to trying to bring forward contemporary issues, again being led by that quote that Dean Poiger shared with us earlier. It's certainly been my pleasure as the Vice President for Student Affairs to work with the many areas that I'm responsible for as we continue to work to build a community that is committed to civic sustainability and one that is a model of inclusion and diversity. So thank you again for being with us this evening.
Well, thank you very much. I know we're all eager to get to the main event, so I won't keep you long. I just want to say how proud the law school is to be a co-organizer of this important event. It's just the kind of thing that ought to happen at universities. And we're grateful to President Aoun for his leadership in building a community that's not just committed to diversity, but one that wants to afford a welcoming environment to every student and every member of the faculty and staff. Just a quick thanks to my colleague Margaret Burnham for moderating this event. She's a pioneer in the civil rights movement, and of course we're all inspired by our graduate Mary Bonato, who earned the rare victory of seeing her vision of justice recently vindicated by the nation's highest court. Today's panel is a reminder that there's still a lot of work to do to ensure that every person is treated as a member of the American family, regardless of whom they love. And like you, I look forward to hearing from our panelists on this topic. I've spent nearly my entire career in law schools because I believe that social change comes about both as a result of legal regulation and also as a result of widespread education. And just because we won a Supreme Court victory doesn't mean we've changed hearts and minds. We saw that after Brown versus Board of Education, how much work remained to be done. And that's what we have to face today. 2 weeks ago, I attended a reception at a downtown law firm, Adler and Pollock. They had awarded a scholarship to one of our first-year students who, when he was 14 years old, told his parents that he was gay, and they kicked him out of the house. And he lived on the street for 2 years as a homeless person, but now has managed to find his way to law school as a courageous individual. I hope that for your sake, your generation will never have to hear stories like that again. So thank you very much, and I look forward to a great evening.
It's then my honor to present to you the host of our series, the distinguished professor of political science and former governor of the state of Massachusetts, Mike Dukakis.
Thanks, Susan. Thank you all very much. I apologize for this voice of mine. I've come to the conclusion that long-distance air travel and the things we fly in are disease factories. I almost lost my eye, literally, when Kitty and I went to Greece to celebrate our 50th wedding anniversary in July because of some organism got into my eye during the plane flight. Instead of spending a glorious week on the island of Crete with our kids and their spouses and our 8 grandkids, I spent 6.5 days in a Greek hospital. Fortunately, thanks to those Greek doctors and nurses, my eye was saved. I mean, it came that close. And then we went out to the West Coast briefly in September to see one of our kids. And I picked up this thing. Finally saw somebody today. She said, it's okay. 8 to 10 week coughs are not unusual these days. It was all about that plane flight. It's great to be with you. And first I want to say thanks to President Aoun, who really put all of this together and got us all together, and very grateful for that. And convinced me to come back from UCLA, where I teach in the wintertime, as some of you know. It's a terrible burden, but somebody's got to do it. For some reason, despite her New England origins, my beautiful wife, who, by the way, will soon be 77 years of age and continues to be the most beautiful Medicare recipient in America, without question. But for some reason, she likes New England winters less and less. But I didn't tell you this, Joseph. So we came back, had a wonderful forum, and lots of you, I suspect, were there. Then I, as is my custom, I walked down Ruggles Street, took the streetcar back to Brookline, walked into our house, no lights. Except we had electricity for the furnace, the refrigerator, and my bread maker. Don't ask me why. So I had a long, dark night at 85 Perry Street as a result of this. That's not going to happen this time. I said this briefly at our first forum in February, but I think it bears repeating. As many of you know, I just celebrated my 80th birthday, and Kitty's soon going to be 77. And we grew up in this town, long before most of you were here, and long before, needless to say, most of you were alive. And it isn't that we don't have much to do. We always have much to do. But when I think about the Boston that Kitty and I grew up in, which was racist, it was anti-Semitic, forget about homophobic, I don't think we even knew what the term was in those days. During the Holocaust, here in Boston, there were anti-Semitic incidents daily and weekly in the city. Think about it. Jack Curry told me, Joseph, that when he was here as an undergraduate in the 50s, there was one single African-American student in the entire campus. And if somebody had told me back then, or even a lot more recently, that one of the two finalists for mayor of Boston would say publicly and proudly that the proudest moment of his life was when he voted for gay marriage legislature. I would have said, you're out of your mind. That guy is the mayor-elect. Think about it. And none of this would have happened, folks, without the work of hundreds and thousands of people, both here and across the country, who weren't content to sit on the sidelines and got deeply and actively involved in the public and political life of their communities and their state and their country. Many of them in very courageous ways. So I'm not only tickled to death to be a part of this great university and to be part of this series, but to be here tonight and to listen to some very special people who are going to discuss this topic with us. Now, I should say one other thing. Two of them are my protégés. I mean, I'm the governor that appointed these two guys to the bench. Where would you be without me, for God's sake? Rick started with me as the chief counsel in the Executive Office of Administration and Finance in 1975, right? You were just a child. I mean, you were. Margaret had only been in practice 5 years when I nominated her for the bench. You should have heard the uproar. Who was this kid? You know, what was Dukakis doing? 5 years? That's not enough time to. She was a great judge. I'm very upset at her for having left the bench, but, you know, it is a free country and she can do what she wants to do. But let me tell you, it's great to have all of you, and especially to have you two with us. I'm very proud of you. Thanks very much.
Thank you, Governor, for that wonderful introduction to the panel, to the life of change in the American environment, and to our Northeastern University family, of which we are all such proud members, and particularly proud of our leadership, of the governor and of our President Aoun, our deans, our provost, my dean, for pulling us all together to talk about issues of the day, about which people may disagree, but about what we all agree are important and central as we define our values as a community, our commitments to freedom and to equality. Now, as the governor intimated, as a Northeastern family and our friends from around the city who are gathered here this evening, we've come to reflect on one of the most dramatic transformations in our culture and in our law, one of the most dramatic movements for change of the last 100 years. And we're lucky, all of us, to be a part of this, to witness it, to watch it, the drama as it unfolded. And we are embarking on this conversation about marriage equality, about the decision of our own Supreme Court, that decision which was a critical building block in the marriage equality movement. We are starting this conversation with two of the pioneers of that decision on the legal front, Justice Ireland and our own law school graduate, Mary Bonato, and as well with Susanna Walters. Dr. Walters is one of the country's leading theorists on LGBT rights and on human liberation. So we're really fortunate to have such wisdom in the room. Now, the topic today, gay rights after gay marriage, runs broad and it runs deep. And in our short time together, we can only hope to lift up some of the most important themes and stimulate further thinking and discussion about the legacy of Goodrich versus the Department of Health and the events that followed that decision. The movement for marriage equality, situated as it is in the larger movement for LGBT rights, has to be understood on its own terms. And our three speakers will point us in that direction and open that conversation. But it does bear mentioning at the outset here that that movement shares some features with two other landmark civil rights movements of the 20th century. And those movements, of course, are the movement for Black liberation and for women's liberation and freedom. And so I want to make 3 points about the commonalities and differences possibly among these three movements. And the first is that all of these social movements, which were boiled down so neatly for us by our president as when he spoke in his inaugural address back in January, as Seneca, Selma, and Stonewall, that they all comprise two distinct agendas. The first, of course, is to win de jure, or legal equality. And the second is to dislodge the social, economic, and cultural hierarchies that characterize second-class citizenship. All three movements must embrace both jobs. Secondly, these three movements ultimately have and must transform the civic consensus on the meaning of freedom in the American culture and political world. Even as the adherents of these movements on both sides argue that their definition of freedom is the real, fundamental, and central one. We can recall, for example, that it was the president of the Confederacy, Jefferson Davis, who said that the South took up arms to vindicate, and I'm quoting, the freedom, equality, and sovereignty which were the heritage purchased by the blood of our revolutionary sires. Those are the words of the president of the Confederacy. And his definition of freedom, of course, came at the price of slavery. And so too, the freedoms associated with preserving the heterosexual nuclear family as the gold standard have come at the cost of LGBT exclusion from the American community. The demands of movements for social justice inevitably enrich our civic discourse and embed in the public consciousness and ultimately in law theretofore unarticulated and even unimagined and unimaginable notions of what liberation and freedom are all about. Thirdly, some of the key engineers of these movements have been litigators. Mary Bonato certainly leads in that list. And that leads us to raise questions about whether the strategic litigation elevates and accelerates, or, on the other hand, retards and minimizes the ultimate liberatory goals of a social movement. In a recent book by a colleague at Yale Law School, Risa Goluboff, called The Lost Promise of Civil Rights, she argues that in rendering Brown versus Board of Education the centerpiece of a campaign for equality, the NAACP perhaps unwittingly jettisoned the movement for equal workers' rights, which had devastating consequences for the African American community in the mid and late 20th century. Litigation helps to mobilize backlash, some have argued, as in Roe versus Wade. Justice Ginsburg has famously ruminated about whether the state of women's reproductive rights would be today different if the states had been allowed to experiment beyond 1973. And some have suggested that as concerns LGBT rights, those who focus on legal equality have, again perhaps unwittingly, exchanged the ideals of economic redistribution and state-sponsored support systems for our families for a marriage license, and thereby have prioritized private rights and social legitimacy over collective struggles for economic justice. So these are the themes and the tensions that run among all of these movements. And now I turn to our panelists, who will have a lot to tell us about perhaps these matters and perhaps many others. And I turn to them with 4 questions, first framed by our Dean Puego. What forces shaped the court decisions 10 years ago, and what forces have shaped the Supreme Court's decisions of this past year? What has been the nature of the dialectic or the partnership between the legal architects of marriage equality in the LGBT movement and grassroots activists on other issues important to that movement? How are we to perceive the role of the courts in this arena? Are they ahead of the curve, behind the curve? And what difference, if any, does it make? And finally, is marriage equality only one step or one misstep, some might say, in the larger and longer struggle for LGBT rights in the United States? So with that, I bring to you our marvelous panel, starting with my dear friend, Justice Ireland, whose long resume is in the program, but of whom I can only say the two of us started together thanks to the governor so many years ago. Justice Ireland is just serving his 37th, I'm not giving it away, his 37th year on the bench, and I was appointed before he was, so do the math, people.
Thank you very much. Well, thank you very much, Margaret, and thank you all. And Mr. President, members of the faculty and students and friends. It's a pleasure to join you today to talk about Goodridge and gay rights and gay marriage. Before I speak substantively, I just want to quickly go over 4 basic points so that we're all starting at the same point. And then I will make some general comments about my experience sitting on Goodridge versus the Department of Public Health. First, there is a federal system of courts that interpret the federal Constitution and federal law, and sometimes state laws. And then there are state courts, including appellate courts, like the court I sit on, that are bound by both the federal Constitution and federal laws and their own state constitutions. The way it works for individual rights is that the federal Constitution sets a floor or minimum for the states. And then state constitutions can set a ceiling by granting more rights than the federal Constitution. So we have the federal Constitution as the floor and the state constitution as the ceiling. The second point is that judges are not allowed to reveal the behind-the-scenes discussions, negotiations, conversations, maneuvers, or developments that explain how a court ultimately arrived at a decision in any particular case, including the Goodridge case. And I do not intend to do that tonight. A judge also cannot explain what the court meant in any part of its decision, except, of course, to state the holding in the case. The whole purpose of an appellate court opinion is that the decision speaks for itself. In that vein, I will just say that the law review article that's mentioned in the brochure that I wrote about Goodridge talks about the aftermath of the decision, including subsequent cases and the public reaction, but does not reveal any behind-the-scenes discussions that the justices had about the case. The third point is that judges should not speculate about or take a position on future as yet unlitigated cases. And I do not intend to do that tonight either. To do so would raise questions about a judge's impartiality and could lead parties to argue in a later case that a judge is biased and has already made up their mind, as evidenced by such past comments. The judge, they would argue, should therefore recuse himself or herself, which means that the judge should not be allowed to sit on that particular case. All of that to say that as much as I might want to, I cannot discuss cases tonight that might come before my court in the future. As an aside, you might be interested to know that one of the ways that those who were against same-sex marriage in Massachusetts tried to undermine our decision after it was announced was by searching through all the speeches made and the articles written by the 4 justices who supported same-sex marriage to see if they could be charged with bias. Now, the fourth and final point I wanted to make before talking about Goodrich is that the Supreme Judicial Court interpreted the Massachusetts State Constitution as prohibiting the ban on same-sex marriage. And this was based on the language in our Constitution. For example, one of the several provisions of the Massachusetts Constitution that we had to interpret was Article 1, which says, and I quote, "All people are born free and equal and have certain natural, essential, and unalienable rights." And so part of the case was we had to interpret different provisions of our state constitution. And every state has its own constitution. And the other 49 state constitutions are each unique, each with very different language. One cannot predict whether or not the language of those constitutions allows a ban on same-sex marriage, which is why the decision of each state court that has addressed the issue has been followed so closely. Now, with that background, let me tell you a bit about Goodrich and then make a few general observations. Goodrich versus Department of Health was a historic case, but it was not a unanimous case. The Goodrich decision was a 4-3 decision. It had a majority opinion, a concurrence, and 3 dissents. It totaled almost 100 pages in length, and it led to calls for the impeachment and removal of the 4 judges who voted in the majority. There were calls for changing how judges were selected, moving from gubernatorial appointments to having election of judges. There were calls for, by the governor, who was Mitt Romney, who wrote to every other governor in the country to say, beware of activist judges who may rule against same-sex marriage. At another point, Governor Romney indicated that he thought a 1-vote majority was not big enough for such an important case, and the case should not stand. At one point, there were radio announcements calling for the judges to step down. Airplanes were flying over different communities with banners that said that the judges should resign. I had personally had visitors come to my church 2 Sundays in a row calling for the members of the church to excommunicate me and to join them in calling for my removal from the bench. And we received thousands of emails, letters, and calls, some of which were death threats. So that's the background on the Goodrich case. Now, in a more general way, let me start by stating the obvious. Because judges can't explain a decision, it's sometimes very difficult and hard when everyone you cross paths with has an opinion about the case. And they're quick to tell you what they think. And it was a challenge because I was not able to respond to the feedback that I got continually, no matter where I went about the case. Although the Supreme Judicial Court was intimately involved in same-sex marriage issues, and the Goodridge case found that our state constitution prohibited a ban on same-sex marriage, it's important to note that courts can only decide the cases that come before them. The courts can't go out and find an issue that they're interested in and then say, we will now issue an opinion. Therefore, whatever the personal views of a justice on a Supreme Court are on any issue, including same-sex marriage, we can't just issue a decision, but we have to wait until parties bring that issue before us. In the same-sex marriage case, we had to wait for whatever social forces sparked parties to challenge the ban on same-sex marriage. The parties first had to try to obtain a marriage license in a city or town. And then after being refused, they had to bring a lawsuit in a trial court. And when they lost in the trial court, they had to bring an appeal. If the parties had not brought suit, the SJC ultimately would not have had the opportunity to speak on the case. In addition, because the court only decides issues raised by parties to a case, it often means, as Goodridge illustrates and my article explains, after a decision is issued, many more cases are filed that challenge the ruling or present slightly different issues, and the court has to flesh out those issues too. For example, one related issue was whether out-of-court same-sex couples could marry in Massachusetts if their home states banned it, as in the Coate-Whitaker case. I also should point out that the other side of the coin of having to wait for cases to come to the SJC that people often don't consider is that once parties bring a suit and then appeal the lower court decision, whether any individual justice wants to decide the issue or not when it is before the court, there's no way for a judge to opt out unless there is a clear conflict of interest. So the SJC was in the thick of the same-sex marriage issue only because the parties brought the issue before us and not because we necessarily wanted to pontificate on the subject. But once a case is brought before the court, all judges do what their job is, and that is to decide the case before them. Now, there were several lessons I learned sitting on the Goodridge case, and I'll be very brief, but I will say the first thing I learned was criticism is democracy in action. People have a right to their own opinions, and so hearing people say, I disagree with your opinion, is not something that we take personally. It's part of our job. Another thing that I learned was that a judge's paramount concern is protecting the integrity of the court. A judge has to make the right call. You can't let your personal feelings influence your decision. The question is always, what is the law and what's the answer to the question that's before the judge? And related to that, a judge must always be impartial. Another thing I learned, because as I told you, there were 3 dissents in the case, is that judges must preserve relationships with their colleagues despite whatever disagreements they might have in any particular case. Now, why is that? Because there's always the next case. And so you move on to the next case, and you don't dwell on any one particular case. You do your best on each case. With that, I will stop and turn the panel over to the next speaker. Thank you.
Hello, everyone. Thank you very much for having us here and having this panel tonight, Mr. President, members of the faculty and students, everyone. I have to say I'm responsible for bringing that to you, and thank you for doing your job as beautifully as you did. I needed to say that. So in the words of Yale historian George Chauncey, There's before Goodridge and there's after Goodridge. And why is Goodridge the touchstone? Well, let me set the table a little bit, if I may. First, long before Goodridge, there had been gay people who wanted to get married. They fell in love, they wanted to stand up in front of their friends and family and commit, hopefully for the long haul, and take responsibility for one another. So in 1967, when the U.S. Supreme Court decided this incredibly important case called Loving versus Virginia, the best named Supreme Court case ever, it involved Virginia's ban on interracial marriage. And the Supreme Court vindicated the freedom to marry for all Americans and also stated that restricting marriage based on race is unconstitutional. Well, there were some gay people who took inspiration from this, that we too are among the all-Americans to whom the freedom to marry belongs, and filed cases in a number of states. However, as one law professor put it, those cases were treated as though the litigants were like these male litigants were seeking a right to get pregnant, i.e. they were crazy. And the cases are painful to read because they're so dismissive of the litigants. In one of the cases that was decided by the Minnesota Supreme Court, there was a petition for review to the United States Supreme Court. The United States Supreme Court at that time, this is in the 1970s, dismissed the case as not even stating any kind of question under the federal Constitution. That's how outside of the circle of citizenship that gay people, and certainly any claim seeking constitutional protections, was at that time. And just to pile on, if I may, so then in 1986, we had another very painful decision from the Supreme Court upholding criminal sodomy laws in a case out of Georgia. And the litigants in that case had argued that the protections in our Constitution for privacy and you're in your own home and it's a consenting relationship should matter. And the court basically said that it was, quote, at best facetious for these people to try to analogize their conduct to anything having to do with family. So, in short, when I started at GLAAD, Gay and Lesbian Advocates and Defenders, where I still work, in 1990, I'll just say that the landscape was not looking so great for marriage. And even more than that, that there was really still a pervasive double standard where there was the law. And then somewhere out here, there was this thing about how the law deals with gay people, and the two were not consistent. The second thing I want to say, just as a matter of background, is that it's very interesting to see, of course, the changes in the last number of years. But there are certainly people who have very strong feelings based on their traditions or their religious beliefs that this is just wrong. And what I have always said to that is, I will absolutely defend your right to believe that and assert that. However, when it comes to what happens at City Hall and the protections of our state or federal constitutions, a person's religious views cannot control the day, nor does anyone's views about morality and whether or not certain people are good or bad play a role. So that's just something to put on the table, and I think one of the concerns that's been out there, and certainly I remember being very hot in Massachusetts, that certainly agitated people, was the idea that somehow the Goodridge decision was going to change what churches and temples and synagogues had to do. And of course, every faith remains free to define what marriage is on its own terms according to its own traditions. Figuring into this too is the role of marriage historically over time, and I just want to be really clear that the dispute that we've had in Goodridge and that we're continuing to sort out today is not unprecedented. I mean, marriage has been a source of conflict for a very long time as a matter of law. Who can marry? Who can't marry? Can you get a divorce? If you get divorced, are you allowed to get remarried if you were at fault? What does the state have to do with telling you whether or not how you conduct your marital relations, whether you can have access to contraception, or whether a husband has to consent to his wife's abortion, and so on? And don't forget this fairly cataclysmic change, which is we've gone from a system where marriage meant Mr. and Mrs. Him. She gave up her legal identity, which was folded into his, to an institution legally of legal equality where rights and responsibilities are identical and mutual. So this issue of marriage for same-sex couples, I just think, fits into a long history of contestation and change. I also want you to know that with respect to this issue, in my experience at least with it, is that it really came from the ground up. when I started at GLAAD in March of 1990, in my very first week on the job, I received a call from a couple in Western Massachusetts who'd been together 10 years and wanted to marry. And I had many calls like this over the years, and I said, I agree with you, and you're right, and it's the wrong time. And we have got to think about what you can do to educate other people and talk to other people about who you are and so on. And in 1990, the reason I got hired for this job in 1990 and it was created was because Massachusetts had just become the second state in the nation to enact a non-discrimination law covering employment, housing, public accommodations and services with respect to sexual orientation, a law that our governor here signed. Thank you, Governor. And I will tell you right now that I sort of had easy pickings in the beginning when I was asked to enforce this law because the discrimination was so blatant, and I think people were just outraged that you could call them out for what they had done and for their blatant discrimination. But what I'm trying to say is we were in a position at that point where there was not even any respect for gay people as individuals, as in the sense that you could just treat them differently because of who they are was just endemic to the situation. So the idea that we would then go to court and file a marriage case just seemed like a losing proposition. So I have always, and I think all my colleagues at GLAAD and many others in the community with whom I have worked have always thought about how do we build structures of equality to make the case and to find the common and shared values with the broader community that make an argument like this make more sense. And of course, there's lots of other work to do too, ways that you can bring cases in court. It's not the only case I brought in court to try to think about how to, secure protections for same-sex families, and what can you do in the legislature beyond non-discrimination. And those things were very, very active here in Massachusetts for a long time. So frankly, I have to say that by the time we filed Goodridge in April of 2001, I certainly believed that there was a clear shot at this, and that for people who were paying attention, this really was the next logical step in Massachusetts. But anyway, I want to just say that before we filed, just since I'm in the before Goodridge piece, I also want to say there were some pretty huge developments out there. So in 1993, the Hawaii Supreme Court did something that shocked me, and I think many people, which was it ruled that telling same-sex couples they couldn't have marriage licenses was discrimination that had to be justified by the state. You needed to have a trial about it. Now, unfortunately, that did not come to fruition because the state constitution was amended in 1998. But it did really start a conversation nationally that was extremely important. And of course, last night we celebrated after 20 years that Hawaii has now become the 16th state to allow same-sex couples to marry. And I think there was some discussion about what triggers backlash. Well, suffice it to say, I think I always had this confusion about backlash because, I remember read something Dr. King said about how backlash assumes that all these rights have been granted and now the rights exist and people think, oh, I don't like this, so now I'm going to agitate against it. No, it's just the question being on the table agitates people so much that they then try to preemptively root it out of the ground to make sure nothing happens. So, example, 1996 Federal Defense of Marriage Act. 1996, the Congress, citing Hawaii and the threat from homosexual lawyer activists, decided to pass a statute with two parts, one that said inviting every state to enact its own public policy about same-sex marriage, which was an invitation accepted with alacrity from everyone who wanted to build a resume in any particular state. So what that meant is by the time we filed Goodridge in April of 2001, there were 36 states that had already enacted laws barring marriage for same-sex couples, and 4 that had already amended their constitutions. Again, this is before we had won the right to marry anywhere in the nation. The other thing it did was say that any state that allowed same-sex couples to marry, this is in effect that they would receive no federal protections. Over 1,000 federal rights hinge on marriage, and those would be foreclosed to any same-sex couple who were married. So, and again, the reason for all of this, it was actually really, it's amazing, having litigated this issue, it was amazing to see that they put their reasons in writing in an official House report to defend traditional marriage against the homosexual activists, and then further to express moral disapproval of homosexuality, something that the Constitution really places off limits as a basis for legitimate lawmaking. Anyway, the other big thing after this, so, it's looking a little rough out there, you would say, I think, in the 1990s. Promise of Hawaii gets snatched away, Congress acts, states are falling over themselves to pass these laws. But we filed a case in Vermont in 1997. And in 1999, the state Supreme Court ruled that same-sex couples had an equal right to the protections and the responsibilities and the benefits of marriage at the state level, and asked the legislature to decide whether or not to include same-sex couples in marriage or in some separate system that provided the same rights. So, as you likely know, Vermont created the first civil union system. At that time, it was in its way a triumph because, we had been in a situation where people were total legal strangers, had no protections, and as the Goodridge court said, marriage protections touch every area of life and death. So to actually have access to some state level protections was extraordinarily significant. However, it was incredibly bittersweet because here we are now creating new institutions for minority groups and segregating them. And that's not what our traditions are about, and that's not equality, and that also really continues the stigma. In any event, we file in Goodridge in April 2001. It was impossible after we got what we got in Vermont not to file here, and we wanted to file here anyway. And I was consistently ridiculed. You think you're going to win this case in court? And it's like, I don't know if we're going to win. I know it's hard to be first, but we are right. This Article 1, why is there an exception? There's this right to marry, and it's so expansive. Why exactly? What is the reason for excluding same-sex couples only? And at the time, the arguments were things like, gay people, you can just write a contract. Imagine saying that to anyone else, write a contract. Other arguments that were common at the time, it's all the reason, the one and only reason for marriage is biological procreation. That's it. Really? So again, I love this line from Goodridge about how people who cannot stir from their deathbed may marry, reflecting on the procreation argument. How exactly do you procreate in that circumstance? And the trial judge who had ruled against us, talking about the age issues, because obviously there's a certain point at which, procreation is just not going to happen. The trial judge said, well, there's at least a theoretical capacity to procreate in those circumstances. And of course, there were plenty of people who were arguing you can't put a stamp of approval on gay people this way, which was really the morality argument. So we went to the Supreme Judicial Court in March of 2003. I argued the case. Chief Justice Ireland asked the first question. The Commonwealth says, this is such an important policy question that it should be left to the legislature to decide. Why is this an issue we should decide? Love that question. Because, we have three branches of government on purpose, and it is the court's job to say when the legislature draws a line or makes a distinction that's on the wrong side of the Constitution. And that's what this case was about, was the constitutional promises of equality and liberty belonging to gay people as well, including in the context of marriage. Well, we waited nine long months, and I also want to just say that in waiting these 9 months, I never lost sight of the fact that it's really about people. And the heart and soul of this is really about people who need their government to treat them fairly. And two of the plaintiffs from Goodridge are here. Mike Horgan and Ed Balmelli from Boston. Just want to say thank you for being there. And I was on my way to Connecticut on November 18th, 2003, and I got a phone call. It's on the website, meaning that the court announced that the decision was going to be issued that day. And I went up to the courthouse to get a copy of the opinion, and the clarity of the very first paragraph said what so many people had long hoped would be true, but had never been stated about gay people by any high court in our nation. The Massachusetts Constitution affirms the dignity and equality of all individuals. It forbids the creation of second-class citizens. The Commonwealth has failed to identify any constitutionally adequate reason for denying civil marriage to same-sex couples. The court even dared to empathize with gay people and confront discrimination, something still rare today. Quote, "The marriage ban works a deep and scarring hardship on a very real segment of the community for no rational reason. The marriage restriction is rooted in persistent prejudices against gay people. The Constitution cannot tolerate such prejudices. In addition, the court went through and essentially decimated every reason that the Commonwealth or friends of the court had advanced. Moral disapproval, on and on, child welfare, for the restriction. So I think it's important to remember that the court had to do this. Some court had to be first, and I think, and I always say that I don't think any court will suffer more than this one did. At least that's my hope, because I realized I had to stay very far away from them, but I realized that they were really going to be taking a pounding for this and for standing for principle. But it's those same principles that caused people to rally on behalf of this decision. This decision and its courage lifted up gay people in this state and across this nation, and I think forever transformed any effort to try to create equality for gay people is judged against the standard of, is it really equal? Is it really the same thing? And Goodridge is the one that broke that historic barrier. And Goodridge, in my view, has made all of the future progress that we've had possible. Now, we could have, the opposition to Goodridge set in exactly 1 nanosecond, and it was serious. There were, in fact, multiple lawsuits. Not all of them were appealed to the SJC, but multiple lawsuits to stop Goodridge. There were multiple attempts to amend the state constitution. There was, one thing he left out about Governor Romney was he also encouraged the federal government to amend the Constitution, and there was, in fact, a vote on a federal marriage amendment that we lost in the House, but not by a sufficient margin. And, in my view, I think it's important to remember that being right, and of course, I do think we were right, and I think that decision was right, but being right is not enough. Change and progress, in my view, are not inevitable. And this is where I think an incredibly happy part of the story also is, which is that people rose up. Even though legislators were targeted with a lot of money for defeat, for standing up for us, every single pro-marriage legislator was reelected. In fact, some who opposed marriage for same-sex couples and voted to amend the Constitution were defeated. And I'll tell you about one of them just really quickly, a woman named Senator Marianne Walsh, who basically, I'd always been on the other side of her for everything. We didn't agree about our vision of the Constitution, people's rights, etc. Senator Walsh read the opinion. She's a fairly new lawyer at the time. And she said, this decision is outside of my comfort zone, but the court is correct. And my comfort zone is not the measure of anyone else's constitutional rights. Well, suffice it to say, her former friends were not happy about this. And she, in particular, was targeted and reelected multiple times. There was a core of legislators with us who stuck with us. And then here's something else. Finally, May 17, 2004 arrives, which is the day that marriages are to begin. There is anticipation, dread, and what happens on May 17, 2004? Joy! Outbreak of happiness! Weddings are happening, people are clapping, the rituals are familiar. As Representative Byron Rushing has said, the best argument for gay marriage is gay marriage. There's nothing like seeing it to believe it. And I also just want to say that in Massachusetts we had quite a struggle here, and it passed 2004 because there were still more attempts to amend the Constitution and the legislative process, and all of those people who met with their legislators, the families who would come in as a big block, 3 generations, and the kids would be there and the grandparents would be there. I mean, all that really, really mattered in terms of opening hearts and minds, so that when Governor Patrick and Senator Therese Murray and then Speaker DeMacy, really all collaborated to defeat any final amendment in 2007, we did, and marriage was secure here because all those efforts for several years to really yank this beacon of equality out of the ground were finally over. And now, in the meantime, what was happening nationally was not so great. Massachusetts was a little bit of an island because Governor Romney had essentially erected this fence around the state so that out-of-staters could not marry here. And there was all of this, incredible political sturm und drang around, whether or not marriage would remain. And we started losing cases in other states. I think people were, I don't know, I'm not a judge, right? But so my sense is, we were losing 4-3 and we were losing 5-4 in states that we really should have won, like New York and Washington and Maryland and New Jersey. But after I think that vindication in '07, we saw wins again in court in Connecticut and California in '08. Connecticut just celebrated its 5th anniversary yesterday. And then, really sweet in my view, just like I always got, the court will ever find that there's some constitutional right to marry. Well, once we went in court, they changed their tune and they said, well, no legislature's ever going to find that there's a right to marry. Well, in '09, 3 New England states voted for marriage. New Hampshire, Vermont with a dramatic override, and Maine. And even though we lost at the ballot in Maine, we got a chance to do it again in 2012, where the people, the voters in Maine and Maryland, what state am I missing? Maine, Maryland, and Washington, voted for marriage. And then in this year, 2013, we've had 7 states so far go to marriage, which is all pretty incredible. So I know we were asked to discuss, is this the end of the line? Are we done? I mean, number one, we're not done even on marriage because there are 34 more states out there. And you all have maps so you can see, you can see this map is the states where things are happening. This state shows where there are bans and so on, and all the question marks are where there's lawsuits pending. But I know there's going to be more lawsuits filed. So things are a little hot right now. But I do hope that at some point, whether it's through the Supreme Court as the final arbiter in our federal system, that we have a right to marry nationwide, or if we need to keep going state by state, then we will do that. I mean, if any of you follow Nate Silver, he says, we'll even get Louisiana and Mississippi and just wait long enough. But I also just want to say that this is definitely not the end of the line, regardless. And I really appreciate Professor Burnham's comments about the legal equality piece, which I very much see marriage is about having that same freedom and opportunity. You shouldn't be fencing a group of people out of a basic civil right. But it's absolutely also about what we see as lived equality. And I know I've talked too long already, so I'm going to stop, but I will say when it comes to employment, when it comes to transgender people, when it comes to the situation of youth, I mean, it's actually with youth, between 20 and 40% of youth on the street are LGBT or T, and it's mostly because of parental rejection or because of victimization at school. There is so much work, and actually we're very excited here in New England now that we have New England under control, on the marriage side at least, of doing some of this other work in terms of the lived equality piece, but I'll be happy to talk more about that when we have our Q&A. Thank you.
A little something up there. Just think of me as the sort of drunk uncle that comes to your wedding. The drunk uncle who comes and someone comes up and says to the drunk uncle, look at my beautiful wedding ring. And the drunk uncle says, oh, the patriarchy bought that for you? So those are my beginning remarks. But let me first thank you all. And I'm thrilled to be here and in such esteemed company. And let me start with the obvious, because I am going to make some critical remarks, which is that marriage equality is a civil rights no-brainer as far as I'm concerned. As they've all said, and as I think any right-thinking person knows, it's just a basic issue of civil equality. So let's put that out of the way for the moment. But there have been robust debates for years in the gay and lesbian community and in academia around gay marriage. But this is a debate I think that the general public rarely hears. Most Americans, I think, believe that gay marriage is, for gays and straights alike, the brass ring of civil inclusion and citizenship rights. It's largely depicted in the media as a battle between anti-equality homophobes, they're out there, and white picket fence PTA-going gays who want nothing else than to be legally wed. So I want to talk for a few minutes about this sort of other side of gay marriage. Now, there are many points of critique here from within the gay rights movement, so I want to break them down just a bit and touch on them. Now, we're going to put aside for the moment the troubling history, and Margaret's talked some about that, the troubling history of marriage as a patriarchal institution that's built on the ownership of women and children, on racial exclusion, on state control of intimate relations. Let's put that aside for the moment. And pretend that it's just this pliable institution that has ebbed and flowed as the seas of time have changed. So the first point of critique I want to put out here is a sort of strategic or political one. There's only so much gay activism and gay money to go around. If the vast majority of resources are put into marriage equality, what isn't getting funded? What issues are backburnered? Focusing on marriage means less focus and fewer resources on what I would see as more important issues, such as equal access to employment, issues of immigration and asylum, the persecution of LGBT people abroad, the economic empowerment of underprivileged people in general, including LGBT people who face particular challenges in many parts of the country. Over $44 million was spent in 2008 attempting to defeat Prop 8 in California, and from 2004 to 2012, other battleground states spent roughly the same amount in their combined efforts for gay marriage rights. Now, you don't need to be an economist to realize that the pie can only be cut so many ways, and that the funding of gay marriage initiatives has effectively taken money away from a whole host of other gay rights causes. I, for one, am offended by the wedding industry that bilks billions out of those who need those funds for health care and housing and everyday life. I shudder at the resources, both of the movement and of individuals getting married, that go into this industry while HIV and AIDS remains a national crisis. And coming as this latest Supreme Court victory did, the one that got rid of DOMA, parts of DOMA, and got rid of Prop 8, it's coming as that latest Supreme Court victory did on the heels of the despicable gutting of the Voting Rights Act. Well, for me, that makes this victory more than a little bittersweet. Now, another critique concerns what happens to a social movement for sexual and gender freedom when it is so completely subsumed into one single issue. Do the Googles, right? Do a Google search on gay rights, and what you'll get overwhelmingly is gay marriage. It has come to stand for gay rights almost exclusively. No other social movement worth its salt has been so identified with a single civil right. And of course, this is not how queer struggles have played out for most of its pre- and post-Stonewall history. Surely, abortion rights have been central to feminist demands, but they've never wholly crowded out other important concerns, such as violence against women, pay equity, family-friendly workplaces, and so on. Voting rights were a centerpiece of the civil rights movement, but the moral gravitas of the struggle was never reduced to simple access to the ballot box, but to a whole range of rights, both practical and ineffable, that came under the rubric of racial equality. But there are also deeper and more ethical and intellectual concerns about this overweening focus on marriage equality. First, many of us are concerned about a further privileging of the couple and of the family in the language of marriage equality. See, I told you, I'm the person you don't want at your wedding. I rarely get invited, it's true. And when I do, I'm sort of segregated, you know. We worry that a new hierarchy will be created now between marrying gays, who are the good citizens worthy of inclusion, and those who create alternative forms of kinship and care. We worry that things like health care and inheritance and Social Security benefits will now be tied and hewed even closer to marriage and further privatized instead of based on need and a larger ethic of social responsibility. In other words, expanding marriage to same-sex couples is the civil rights thing to do, but it only further marks off the line between married folks worthy of benefits and rights and social supports and everyone else. It provides more benefits to more people, but doesn't challenge the idea that benefits should accrue to married people that don't accrue to those who choose to live their lives in different ways. Second, we are concerned about the kinds of social arguments used to make the case. So, for example, one of the plaintiffs in the Prop 8 case spoke afterwards, I think on the steps of the Supreme Court, that she now felt her children were as good as other children. They were now legitimate. I remember watching this on television with my 19-year-old daughter, a daughter of a proud lesbian single mother by choice, who sort of looked at me and said, dude, as she is wont to do. I said, dude, really? Legitimate? I kind of thought I already was. But lawyers and activists and plaintiffs typically invoke a very particular vision of family and kinship when arguing for same-sex marriage rights. A vision that often ends up demonizing single parents and those whose gender and sexual lives don't look like those of married heterosexuals. One shouldn't have to marry to have one's family supported legally and respected socially. In fact, now there's a whole movement for making the folks making what they call the conservative case for gay marriage, and one of the sort of disgusting actually, but one of the sort of lead figures of this is this guy David Blankenhorn, who was with Maggie Gallagher, one of the big foes of gay marriage, and now he's seen the light. Why has he seen the light and joined the gay marriage cause? Because he says gay marriage then will allow gays ties closer to state-sanctioned conservative family values and pushing them further away from those terrible ideas of sexual freedom and gender non-normativity. So it certainly has made some strange bedfellows. Another argument that you often hear is that legalizing same-sex marriage will not alter heterosexual marriages at all. Let us in, we say, because we are just like you, and our access will not shift the institution nor your relationships. But of course, this is a curious argument to make. For if marriage has been built around gender opposition, indeed has been restricted to it, and gender inequality is in fact learned in the crucible of the heterosexual family home, then surely degendering that institution will hopefully shift it. Even National Cathedral Dean and Episcopal priest Gary Hale argues strongly that gay marriages can and do affect straight ones. When conservatives say that gay marriage threatens my marriage, I used to say, that's ridiculous, says Hale. And of course, that's been the line by most of the gay movement. We all mess with your marriage. It's fine. Hale now says, yeah, it does. It's asking you a crucial question about your marriage that you may not want to answer. If I'm a man, am I actually sharing the duties and responsibilities of married life equally with my wife? Same-sex marriage gives us another image of what marriage can be. That's from Hale. So this gets to the heart of the problem for gay marriage advocates. How can both these things be simultaneously true? Can gays reasonably argue that gay entry will not alter the social fabric, but just gently expand it, while at the same time claiming gay marriage as a fundamental civil rights issue? If it is a core civil rights issue, then shouldn't we take the strong or robust position that integration of an institution, a school, a neighborhood, a workplace, a relationship, radically changes that space, alters both its exterior and interior geographies? So I have to say then, if it doesn't change gender normative, often abusive, deeply unequal heterosexual marriages, then why does it matter at all? If queer marriages don't alter straight sensibilities around gender and intimacy and family, then they are strangely not queer at all, and not worth all the fuss. Another worrisome argument, often but not always used in gay marriage cases, is the born that way argument. In amicus briefs and legal argumentation throughout the country, and by the way, in a more general sort of discourse, a popular discourse all throughout the country, Advocates argue that gays should get their marriage and other rights because they are born that way, and therefore their immutable homoness puts them in the same category as other groups with supposedly immutable qualities. And it's worked out so well for those other groups as well. So we can't help ourselves is the flawed, sad identity argument at the core of much of marriage argumentation and indeed pro-gay discourse more generally. Indeed, sometimes the anti-gay activists, and I have to say sometimes in court this particularly comes up, sound like the postmodern feminists here. So they describe sexuality often for the wrong reasons, because they're awful, we know this, but they sometimes describe sexuality as fluid, as complicated, as changing. You know, it's a sexuality, it's, you know, not something that's just hews to particular kinds of acts and identities. Our side, on the other hand, often sounds like old-fashioned biological determinists, talking about a hardwired sexuality that's inborn and inevitable. So some of the discourse of marriage equality then reminds me of why I've been so frustrated at its centrality in the gay rights movement, even as I do celebrate it. I do. I know I don't sound like it, but I do. I do. I cry, I celebrate, I'm happy, whatever. Go get married. I'd rather poke my eyes out with a spoon, but do it, really. We are being told that this decision makes us more equal and our families more real. That this is the culmination of the long march of progress, and we just need to get those other states to kick in, and we'll live in a happy rainbow world of official homo love. Marriage is called by Ted Olson, who argued the Prop 8 case, and many others arguing these cases, the most important relationship in life, or the building block of a social order. It is held up as central to civilization and gay inclusion, and is imagined as the core right we must win to guarantee us happiness and belonging. But we need to ask, is this more core than the right to a job, to health care, to bodily integrity, to control over our own reproductive lives? Love is not more legitimate or good or valuable if the state makes it official. And garnering a basic victory is not the same as making the world a more genuinely amenable place for sexual difference and gender non-normativity. The queer movement should be about liberation and sexual and gender freedom, and not just about equal access to deeply flawed heterosexual institutions. Thank you.
Well, thank you so much, Susanna and Mary and Chief Justice Ireland, for those cogent and provocative remarks from all three of you. Thank you. They were really three wonderful presentations. And I think it's time now to engage all of you who are in the audience. And so I invite you to step up to the mic and to ask a question. And please tell us who you are, and then give us your question, and we will try to grapple with it. Well, in that case,
Hi, I'm William Joyce. I'm a political science student here at Northeastern University, and I was wondering if the panel could talk a little bit about, in cases such as Romers and Lawrence and Windsor, the court has always used the rational basis standard for deciding these cases. Why hasn't the court gone the extra level, found gender identity, found sexual orientation as a suspect class that's deserving of higher levels of review, such as strict scrutiny? Could you talk a little bit about that?
sounds like a question for Mary.
Yes.
Is this on? Is this on? Okay, so just a quick thing here. When government has to draw lines all the time, You know, who gets the in-state tuition, you know, who's going to be regulated as an optometrist versus an optician. I mean, all kinds of things, all kinds of lines. And normally courts don't want to get involved in second guessing those lines. And when they don't want to get involved in all of that because it's just part of the routine classification of government, they employ something called rational basis review. And just to summarize quickly, it's presumed to be that the legislature was acting correctly, no reason to second guess them. And as long as there's some conceivable reason, any conceivable reason for why they might have done what they did, even if they weren't thinking about it at the time and the court can invent one, then it's okay. And that is the standard by which gay people's, discrimination against gay people has been judged. That we have the burden of negating any conceivable reason and trying to imagine what some smart judge might think of on the bench and try to anticipate that and negate it. So I have to say I personally am not thrilled about the fact that discrimination against LGBT people is considered presumptively constitutional. So your question is, well, why hasn't it gone further? It's a great question. Because there is a test. There is a test by which the courts will say that it's going to look more closely. They're going to look more closely when a line is drawn around a particular characteristic. If you think about sex, you think about race, you think about, you know, religion, ethnicity, and so on. Those are the kinds of things where the court looks more quickly. The Supreme Court, at least, has not been eager to let new groups in for a really long time. There is a test, or at least there used to be, where the two major factors the court looks at are, you know, one, is there a long-standing history of discrimination here? And is that discrimination related to people's ability to actually participate and contribute in society or not? I mean, in other words, is this really just discrimination that's irrational? You know, you brought up the issue around immutability. Sometimes the Supreme Court has said that immutability or having a distinguishing characteristic matters. And sometimes they've said that relative lack of political power matters. So that's why those issues sometimes come up in court. But essentially, there was a very forceful presentation to the Supreme Court and a bunch of lower courts on this issue. At this point, we all bring in experts to talk about the history of discrimination in particular. It's the parenting where people try to make an issue to say that gay people are not equally up to the task of parenting. It's an issue that's brought up by the other side. So I think that the reason that courts have not gone there, or the Supreme Court in particular doesn't want to go there, is because if it goes there, then what that means is all the state discrimination that's out there, which there is a considerable amount, will be subject to review under that heightened standard, and in all likelihood will not survive. So in other words, by making the decision to say, we're going to look more closely at, you know, we're going to assume actually, we're going to flip this. We're going to assume that when a line is drawn that uses sexual orientation or gender identity, that there's something foul going on here. And it's the state's job to come forward and justify it. I don't think the court's ready to turn those tables. The other thing is, the court may not be interested in that paradigm at all anymore. And they just haven't said so, except by their actions, i.e. not including any other people in this paradigm anymore. And, you know, you see more of the Supreme Court in particular doing this balancing, you know. This is what's your reason, we're going to try to figure out how it all works. And you've seen that happen actually in a number, and actually I think in Lawrence and to some degree in Windsor. So in any event, I'm not sure we're going to get there or not, but now in the Second Circuit, which covers New York and Connecticut and Vermont, there is heightened scrutiny for the moment. I know that many people are still trying to push it. I mean, I've always been a rational basis kind of person. I feel like there is no good reason for any of this discrimination, and we can refute all of it. And in fact, Goodridge was a rational basis ruling.
Thank you.
My name is Sam Bernstein. I'm a professor in the Department of English. I simply like to say first that it's a great honor to have presentations of this sort. It's intellectually extremely exciting, and it's very valuable. And I think the people who organize certainly deserve much credit. My question has to do with the ways in which matters such as the gay rights issue, gay life generally, and other issues may be solved. Chief Justice Ireland spoke at the beginning of the way in which law functions to help to change matters. And I have a question for all members of the panel having to do with other ways, other means by which changes occur. Let me just give a word of background. This has been an intellectually, as I said, exciting experience for me, but also an emotional one. In 1983, I had the honor of serving as the chief of the chairperson, essentially, of the Faculty Senate Agenda Committee. And I received on my desk a note from a gay rights representative telling me that the treatment of gay people at Northeastern University was highly insensitive. There was harassment and really terrible conditions, and asked if the Faculty Senate Agenda Committee could take up this issue. And at first, my entire committee said, yes, we'd certainly think that's worthwhile. And then, over time, things happened at the university which made it very difficult for us to take up these issues. For example, a very distinguished member of the Faculty Senate rose and spoke at great length as to why people who are gay are vermin at the Faculty Senate of a major university of the United States. After that, I was called repeatedly into the offices of administrators telling me to drop this issue. Drop it, get away from it. Thank God there was a modest little shy woman on the agenda committee with me who stuck with me. The other people were frightened by what was happening all around us, both from the administration, from the faculty, and we continued to fight on. And I think when I see this tonight, the mixed feeling is basically, gee, how far we've come with many people who are gay with important positions here and so on and so forth. On the other hand, as a few of you have said in your comments, there are various levels of change, and we haven't perhaps reached as far as we need to do. I'd like to add one thing that's of concern to me today, since I went through this, and the concern is the following. I believe that the issue that Northeastern is really facing today is the matter of religious harassment and religious insensitivity. And my question to you is this: how can a university solve problems such as gay rights, rights of minorities such as African American, rights of people of various religions, and still maintain their reputations outside, and still maintain the academic and administrative integrity so that the university will be viable?
Thank you, Professor Bernstein. I'm going to exploit the position of the chair for a moment, and I'm going to just try to collect a couple of questions because there's quite a line there, and we do want to get out and circulate and have drinks. So, speaking for myself. So let's take about 3 questions, and I'll ask the panelists to hold their comments and then respond.
Yep. My name's Chuck Colbert. I'm a reporter for gay media here at Boston and around the country. And I have a question about religious liberties and how they are playing into the Employment Non-Discrimination Act. We saw some, I believe the Massachusetts decision and the Connecticut decision there are no religious exemptions, as I understand that. And I think there are some that have more and others. And if you could talk about concerns, opportunities, challenges that these various religious exemptions pose, I think that would be really helpful for both legislative and legal as they've come up. That's
Thanks,
basically
Chuck.
my question.
We're going to get to that in just a moment.
Hi, my name is Marissa Korn. I'm a second-year political science and economics major, and then I also minor in women's gender and sexuality studies. So my question is primarily directed towards Professor Walter's discussion. So before college, I only knew about, I guess, more like working within the system, ways of achieving equality, so legal challenges, etc. And only till I became a college student did I really learn how to question, structural inequity is not only like for women's rights, but for gay rights, for a lot of things. So I guess my question is, how can we expose the general public to this? Because I didn't know until I was in college that maybe the systems which we're working with are actually flawed, and how we can go about fixing them instead of just working within them.
So that sounds like a question for Mary Bonato and one for Professor Walters. And then we'll take the next 3.
Well, look,
you're here and feel that our work is well served by students such as yourself. I mean, I do think one of the things that has to happen, and I think there are a lot of us here at Northeastern and a lot of, around the country who are trying to make their work more public and trying to translate some of these ideas into more general discourse. But I do think part of what has to happen is precisely forums like this and an ability to talk about the differences within communities that doesn't devolve into a sort of shouting match. And I think one of the things that is a shame is that the critiques, and this is part of why I wanted to talk about it here today, is that some of the critiques from within the gay community, which have been robust, interesting, engaged, thoughtful, get little airtime. And, it really does, if you watch the news and read the newspapers, by and large, with a few exceptions here or there, you would, in fact, think that this is a black and white issue of which there's not much nuance. I don't think that's true, by the way, with how the lawyers think and present it. I don't think that's true, but I think that is the media presentation of it. So I think part of all of our task is to always complicate. To always complicate, to really, be the grouch at the wedding party if we need to be.
Thank you. We'll have this conversation another time. Okay, returning to the issue of religious exemptions. Okay, so here's what's happening. I think the right wing, if I may call them that, realizes they're going to lose on marriage. And they have been very explicit in referring to a, quote, Plan B. And Plan B is to wall off people who want nothing to do with gay people and their relationships and their marriages by creating a broad right to discriminate and have nothing to do with gay people, whether they run a business, whether they work in a public accommodation, no matter what. And that's what they're calling it, Plan B. And so what you see now is an attempt in state legislatures and now at the federal level with respect to this Employment Non-Discrimination Act, which has been kicking around for over 20 years and just finally had its second Senate vote and will have no House vote. But in any event, what you see is a religious exemption in it. Normally what happens with religion is people, religious institutions can discriminate against other religions. They can favor their own adherents and so on. But they can't discriminate based on race, gender for the most part, and so on. But this would create an explicit right to discriminate based on sexual orientation. Completely permissible. And then, further than that, I actually just, before I got here, got a memo about some internal deliberations around legislative history around some piece of this. But it's basically, they're trying to make it as expansive as they can. And what I see in the states, and to some degree at the federal level, is an attempt to make it possible for individuals in any circumstance, businesses in any circumstance, to put their beliefs ahead of any non-discrimination law. And I have to say, I feel like that is a tragedy, because the whole idea of non-discrimination is that, again, it's about non-discrimination. You don't serve your customer, you don't have to run a gauntlet about, is this the kind of business that's going to approve of me or not? When Maine had its election, in 2012, this is obviously an issue we had to deal with and talk to people about. And there was a woman who identified herself as a Christian photographer in an ad. She wanted to appear in an ad. And she said, look, I'm really clear about my beliefs, but I'm also really clear about what my obligations are. And from my perspective, this is more weddings to shoot, which was nice. Which was nice. She has more weddings to shoot. But again, I am just so concerned about breaching this promise of non-discrimination and creating these zones where still gay people and trans people are going to have to run a gauntlet.
Thank you both.
My name is Stephanie Wright. I'm a senior at Northeastern. I studied journalism, law, and Spanish. And we've talked a lot today about the local perspective on gay marriage with Goodrich and expanded a little bit nationally to the movement that's kind of moving across the country through different states. But I was wondering about a more global perspective about where gay rights is going internationally, and if leaders such as yourselves, who are so important to the movement here in the United States, should be having a role in progressing gay rights outside of the United States as well.
Thank you.
My name is Brian Levine. I'm a third-year law student. Professor Burnham was my constitutional law professor. So I'd like to ask a question, even though I've kind of understood that this hasn't really been of issue, but there's 3 sections of DOMA. The first is just the title. The third was what was struck down, basically the federal definitions of marriage. And the second was kind of what was supposedly the argument post-Hawaii to basically say, ignore the full faith and credit if you feel like clause. You don't have to recognize other state marriages. And I know in practice that may not have come into play, but I'm curious if there's any either movement, either through litigation or maybe at some point through legislation to take that off the books, because it technically is still in effect, even if it doesn't have any practical impact.
Thank you, Brian. So we've got 2 more questions, and then are you holding all this together, panelists? You are, great.
But to do 2 more? Did you do another
We're
one?
going to take 2 more, and I think we'll wrap it up at that point. Can you wait, Mary?
Yeah, I mean, just in terms of the
Guess not.
I don't need this. In terms of the issue about who was asked about the international situation, I mean, look, it's awful. And, beginning and end of the story, it's awful in most places. Nevertheless, I do think there's there's an issue about exporting a political, a U.S. version of what constitutes gay rights onto other national contexts. That is really problematic. Our particular way of understanding sexual identity and the relationship between gender and sexual identity that has a history of American sexology and American sociology is particular and not necessarily shared by other nations who have very different histories of thinking about the sexed body and its relationship to desire and identity. So I think it's crucial as we engage, and I think asylum's actually a major issue that we should think about. But as we engage in international struggles around gay rights, we need to understand that the very terms of the discourse might be very different. So that even the way we talk about gay rights as a minoritarian identity position might have no resonance in other locales. And so I think it's just very important to do that with care. I guess that's what.
So Mary, on Brian's question about DOMA, and then we'll take the next 2 questions.
Okay. Okay, so DOMA Section 2 basically was an invitation to states to pass laws about same-sex marriage, and it does remain on the books, and there is a bill called the Respect for Marriage Act, which actually has considerable support in the House and Senate, but will never pass.
You guys hear her back?
To repeal. Sorry,
Try to
okay,
speak up
sorry,
a little.
sorry. Yes, so there is a bill called the Respect for Marriage Act, which is pending in the Congress and has a considerable number of House and Senate supporters, which would repeal Section 2, among other things. So here's my thought about Section 2. I feel like it's a red herring. Sorry. I feel like it's a red herring because guess what? States already had the power to pass laws and say we're not going to have X, Y, or Z kind of marriage. And if Section 2 were repealed tomorrow, guess what? We'd still have this huge edifice of state anti-marriage laws and amendments that have to be addressed. So in the end, the question is it permissible under our equality and due process provisions for states to have these fences up against gay people?
Thank you. These are our last 2.
Hi, I'm Elizabeth Torres. I am a political science major on campus here at Northeastern, and I'm also a part of the Social Justice Resource Center on campus. One of the biggest things, I come from a state where I work very heavily with a home called Rainbow House, which is for homeless queer youth. My mom and I are very concerned because the majority of them have been through the foster care system in which their foster parents are forcing them to align with the identity that they were born with and also discouraging any sort of homosexual relationships outside of the home and also disconnecting them from any sort of resources for LGBT queer youth outside of the home as well. And I was wondering what are the legal and maybe the social ways also on how we can protect those queer youth so that they are not discriminated not only by their biological parents in the beginning and getting taken away for abuse, but also from foster parents who are supposed to be there for their protection.
Yeah, thank you for doing that work. There's only so much I can say about this except to say that we're in touch with 6 states in New England about how they are handling these issues and what kind of training is in effect for the caseworkers in the state that's going through to the foster parents and so on, and what systems of accountability are in place, and whether or not there will be follow-on action. It's a very important issue.
Yeah, and the only thing I would add about that is that, I think that's part of the necessity of reinvigorating a queer movement that has a broad-based social justice agenda, that sees its queer youth as, central to its mission, that sees women's reproductive rights as central to its mission, that sees, workplace equity as central to its mission. And I think there's a long history of that in the queer movement. But there's also a long history of a more narrowly focused queer movement as well.
Can I actually say something? I wanted to say something about this, okay? Which is, I think if one were to look at media portrayals of the movement, then I think the professor is correct. You would think it's all about marriage. I'm sorry. If you were to look at media, then yes, the professor I think would be correct that the media portrays our movement as about marriage. But thankfully, we're able to walk and chew gum at the same time. And from my perspective, having been in this movement and working at GLAAD since 1990, and I will spare you the details about just how bare and difficult our circumstances were trying to survive at that point, and so on. I will just say that marriage has brought considerable resources into the movement, much of which are spent on non-marriage issues. And so I will say that I feel like, from my perspective, having been in this for a very long time, that as much as we get a lot of attention for our marriage work, what is completely apparently off the radar of the media is all the other kinds of incredible stuff that is happening. Doing youth work is not new. Doing trans work is not new. Doing employment work and all kinds of other family work is not new. It's not getting enough attention because marriage does dominate. Media likes a good story. We all know that. But, I think particularly in this region, we'll be able to more sensibly re-engage on a number of other really compelling public policy issues and continue that work. I'll also just say that I think the marriage work has been extremely helpful in busting stereotypes. I mean, when I started at GLAAD, one of the most common questions I received was, isn't it criminal to be gay? And how do you find more homosexuals? And the idea being that you recruit. So, I mean, the stereotypes... No, not in the way that they were talking about. So the stereotypes, I mean, were so awful. And still, the child molester thing and so on. So if you think about marriage and the way that it has shone a light on gay people who do want to marry and gay people who don't. But, that whole evolution has made such a difference in how the general public is now able to interface with us around a whole range of issues. So I think the resources that have come in have lifted many boats despite the media presentation, and that destroying these stereotypes about who we are has also been extremely helpful for going forward.
Hi, I'm Emily Balding, and I'm a senior at Northeastern. Oh, sorry. My question was just about the role of media in the gay rights movement, specifically. Recently we've heard a lot of talk about, especially television shows, even politicians have made references to Will and Grace, even Glee or Modern Family as kind of having a role in bringing the gay rights struggle into kind of the living rooms of people who maybe had never even thought about it before. But there's also kind of a lot of criticism about media, of how its portrayal of, it's usually white men's relationships only, as trying to kind of, again, what you're talking about, fit queer people's, roles into sort of the heterosexual kind of marriage, same sort of system. So I kind of wanted to ask about what your opinions are of media and how important has it really been?
Thank you. Steve has written some books about that, but I won't go into it. You said it all. I mean, visibility in public media is a double-edged sword. It is sort of a necessary but not sufficient condition for social change. So that it's necessary to have, it's necessary to not be consigned to the netherworld of invisibility and of absence. But what comes with that is often a shortening and a narrowing and a re-stereotyping and a tokenizing And that's inevitable, and it's no different with many other minority groups. And I think part of what needs to happen with that is sort of not for us to jump on the gay visibility bandwagon and think in a similar way that we might think about marriage rights, that now the battle's over. We've got our, homos on sitcoms, and we've got our taffeta in Massachusetts, and we're done, and the movement for social justice is over because you can watch us and you can marry us. It is, for better or for worse, a more complicated and a long-term process that means transforming both those intimate relationships and the representations of them.
Thank you. Thank you, thank you, thank you. You've been a wonderful and patient audience, and now we are going to ask you to join all of us for lemonade. But I just, before you leave, I really do want to thank Chief Justice Ireland and Attorney Bonato and Professor Walker. It's been a really rich discussion.
Thank you to our moderator, Margaret Burnham. I too hope that you will join us to continue the conversation 10 years after Goodrich right here in the lobby.